Again, good morning, everyone, and thank you for joining us this morning. On behalf of the members of the Executive Appointment and Administration, we would like to welcome Governor Apatang and Lieutenant Governor Mendiola's representative, Mr. John Paul Regis, along with Ami Shai, excuse me, the appointee, Presiding Judge Roberto C. Naraha, elected officials, dignitaries, and members of the general public. Before we proceed forward with this public hearing, let me first introduce the members of this standing committee. To my right side of the aisle is the Vice Chairman of this committee, Senator Jude U. F. Snyder from the 2nd Senatorial District, Tinian. And next to him is Senator Manny Castro from the 3rd Senatorial District, Saipan. And to my left side of the aisle is the Vice President of the Senate, Senator Corina Magofnia from the 3rd Senatorial District, Saipan. And next to her is Senator Ron Calvo from the 1st Senatorial District, Rhoda. And I'm the chairman of this standing committee, Senator Francisco Q. Cruz from the 2nd Senatorial District, Tinian. I would also like to announce a couple of things in the interest of informational purposes regarding code of conduct during this public hearing. Today, the members of this standing committee is conducting a public hearing on the appointment of Presiding Judge Roberto C. Naraha to serve as Associate Justice of the Supreme Court of the Commonwealth of the Northern Mariana Islands. The public will be invited to make comments as to whether you support or oppose the appointee before us this morning. We value your input. However, any comments beyond the facts of the appointee will not be entertained, and such comment will be removed from the record. At the same time, please observe minimal noises in disrupting this hearing process, and please turn your electronic to a silent mode. Thank you. Let us now begin. This public hearing is now in session. Today is April 1st, 2026. At approximately 9:56 in the morning, here at the Honorable Vice Speaker Jesus P. Mafnas Memorial Building, Senate Chamber, here at Capitol Hill, Saipan. This is a public hearing regarding the appointment of Presiding Judge Roberto C. Naraha by Governor David M. Apatang and Lieutenant Governor Dennis Mendiola to serve as an Associate Justice of the Supreme Court of the Commonwealth of the Northern Mariana Islands. Mr. Devin Macaranas will be assisting this committee. Mr. Ben Terlai will be our Sergeant at Arms. Mr. L.J. Castro will be covering social media. Mr. Delbert Camacho will be in charge with the IT, and our legal counsel will be Joe Bermudez, and they will all serve accordingly for this public hearing. At this time, I would like to ask Mr. McCarnes to please call the roll.
Senator Ronnie M. Calvo.
Present.
Senator Manny T. Castro.
Estiga.
Senator Francisco Q. Cruz.
Here.
Senator Jude U. Hofschneider. Senator Corina L. Magofnia.
Present.
Senator Donald M. Manglonia. Mr. Chairman, 5 members are present and 1 member is absent.
Thank you, Devin. With 5 members present, we have the necessary number to proceed with this public hearing. However, the floor leader of the Senate, Senator Donald Manglonia, is excused. At this time, I would like to ask for a motion to adopt agenda. There's a motion for the adoption of this morning's agenda, public hearing agenda, and was seconded. On favor of that motion, say aye. Opposed, say nay. Motion carries. At this time, I'd like to ask Sergeant Terlai to please escort the appointee and the governor's rep to the chamber. And sir, before you proceed, please state your name for the record. Thank you.
Good morning, Hofadais Antiro, Honorable Chairman Francisco Q. Cruz, Honorable Vice Chair Jude U. Hofschneider, and Honorable Senate members of the Executive Appointments and Government Investigations Committee. For record purposes, my name is Jean-Paul B. Regis, Special Assistant for the Administration under the Office of the Governor. On behalf of the Honorable Governor David M. Appointee and the Honorable Lieutenant Governor Dennis James C. Mendiola, I thank you for conducting this final public hearing on the island of Saipan and for the opportunity to appear before you today. It is with distinct honor to present the Governor and Lieutenant Governor's nominee, the Honorable Presiding Judge Roberto Camacho Naraha, as Associate Justice of the Supreme Court for the Commonwealth of the Northern Mariana Islands. Presiding Judge Naraha is a distinguished jurist and a graduate of the Gonzaga University School of Law. With a judicial career spanning more than 24 years on the Superior Court bench, he is one of the Commonwealth's most revered and experienced legal authority. Throughout his tenure, Judge Naraha has earned a reputation for maintaining the highest ethical standards for fair and equitable justice. He has an epitome in successfully managing high-volume dockets, engages on enhancing the operational efficiency of the court system, provides strategic oversight of essential court divisions, and serves as a dedicated mentor to members of the legal community. His extensive background in overseeing complex criminal and civil litigation, combined with his prior service as an Attorney General and Chief Public Defender, uniquely qualifies him to elevate to the Commonwealth's highest court. Governor Appointee and Lieutenant Governor Mendiola place their complete trust and confidence on Presiding Judge Naraha to serve as the next Associate Justice for the Supreme Court of the Commonwealth of the Northern Mariana Islands. Judge Naraha stands ready to address any questions or concerns you may have, and we respectfully seek the committee's favorable consideration as we look forward for his confirmation of his appointment. Mr. Chair and members of this Senate body, thank you, Jesus Moses and Giliso, for the opportunity to introduce him to this august body again. Thank you.
Thank you, Mr. Regis. And before I recognize Presiding Judge, please can you rise so our staff can minister to you.
Honorable Presiding Judge Roberto C. Naraha, you do solemnly swear under the penalty of perjury that the testimony you shall give in the matter at hand shall be the truth, the whole truth, and nothing but the truth. Thank you.
Thank you, Presiding Judge. I know that we went to two public hearings, one in Rhode and one in Tinian, and you have delivered additional testimony, and also you have completed all required documents and submitted to this body. But do you have anything else to share with us this morning? You have the floor, and before you proceed, please state your name for the record. Thank you.
Thank you, Mr. Chairman. And thank you, Special Assistant John Paul Regis, for the nice introductory remarks. I extend my profound appreciation to Governor David Appointee and Lieutenant Governor Dennis Mendiola for nominating me for the vacant position of Associate Justice of the NMI Supreme Court. Buenos dias and good morning. Once again, I am deeply honored to appear before this 24th Northern Mariana Island Commonwealth Legislature Standing Committee on Executive Appointment and Government Investigation of the Senate. Honorable Senator Francisco Cruz, Chairman. Honorable Senator Jude Hofschneider, Vice Chairman. Members. Honorable Senator Ronnie Calvo. Honorable Senator Manny Castro. Honorable Senator Karina Magofnia, good morning. It is my profound honor to be here today as a nominee to be an Associate Justice of the Supreme Court of the Northern Marianas Islands. On behalf of myself, my wife Frances, and my son Robert Jr., family who are behind me, and there's a lot of family members from both sides of the aisle, and friends who are here with us today, as well as family and friends who are unable to be with us. We would like to extend our deepest and sincerest appreciation for holding this third and final hearing here in Saipan at the Senate chambers. We are proud and grateful to be here today in service of the people. In both Rhode and Tina, we normally would have the municipal council. I don't see that here today, so in any case, I would just recognize the municipal council. Let me also recognize the Mr. Galvin Guerrero, the NMC president, and Mr. Yumo, DPW secretary. For the past 24 years, I've presided and continue to preside over all the various court dockets here in Saipan at the Guma Justicia. In my commitment to the rule of law, I pray that I have carried out my duties with humility and fairness, that I have served this community with professionalism, courtesy, kindness, dignity, and respect. I hope that I have sought equitable solutions in the many cases that come before me each day, so that our citizenry may have the confidence that our judicial system is fair, impartial, and grounded in justice above all else. At the same time, I also recognize the vital importance of our appellate process. If confirmed as Associate Justice of the Supreme Court, my duties would include serving as the final interpreter of the Commonwealth law. Under the leadership of Chief Justice Castro, the Supreme Court is responsible for administering the judiciary in ensuring meaningful access to justice for all people of the Commonwealth, where the duty includes upholding the rights of the people as enshrined in our CNMI Constitution, as well as the rights of the U.S. Constitution, or applicable under the covenant. This duty includes preserving the indigenous traditions of our Chamorro and Carolinian people. If confirmed, I will be joining two sitting justices who have combined total of about, if not over 70 years of experience as trial court judges and appellate jurists. It would be an honor to join them. I will be joining the two jurists to fill in the vacancy created by recent departure of the Honorable Associate Justice Perry Bienes. With their combined 70 years of judicial experience, Chief Justice Castro has built an extensive record in community outreach educational programs with a continued commitment to other public services. This includes programs such as the Moot Court Competition, Law Day activities, Law and the Freshman Legislator, and other educational initiatives. Associate Justice Manglonia has significantly developed advanced technology capabilities in our judiciary. His expertise in our judiciary financial operation is exceptional. As a freshman associate justice, I will be entering an already well-established, efficient, and experienced CNMI Supreme Court. At this time, I extend undunkling and sijus maasi, and my deepest thank to all supporters for your testimony to follow, and above all for being here this morning to support me and my family. Thank you, Chairman Cruz, and respectfully, I humbly submit myself to this committee for continuing examinations.
Thank you, President Judge Naraha. At this time, I'd like to entertain public comment, but before I allow anyone to come forward to deliver testimony, whether you're in support or not in support, before you proceed with your testimony, I would like to ask that you state your name for the record. At this time, I open the floor for public comment.
Good morning, Chairman Francisco Cruz and members of the Senate Committee on Executive Appointments and Government Investigations. My name is Galvin de Leon Guerrero, and I'm honored to have served our community for 3 decades as an educator. I come before you today in my personal capacity, and I thank you for this opportunity to speak. And Chairman Cruz, if I may, given some schedule conflicts, if I may be allowed to speak in support of the appointments of all 3 appointees, Presiding Judge Roberto C. Naraha as an Associate Justice to the CNMI Supreme Court, Judge Joseph N. Camacho as a Presiding Judge to the CNMI Superior Court, and Attorney Joey P. San Nicolas as an Associate Judge to the CNMI Superior Court. So Chairman Cruz, if I may speak on all 3? If that is acceptable, Chairman?
Sure, go ahead.
Thank you. The extensive resumes and illustrious careers of these legal professionals more than speak for themselves, with these gentlemen having distinguished themselves as outstanding in their respective fields. Whether as attorneys, judges, or even scholars, they have achieved far more than my humble words can justly honor. So please allow me to speak plainly based on my personal interactions with them. What we all look for in the judiciary is quite simple. We want justice. We turn to the courts for fair, impartial, and reasoned judgments. Most importantly, we believe in our justice system because we trust the individuals leading that system, a trust we only grant to those with impeccable character. And that is what Presiding Judge Naraha, Judge Camacho, and Attorney San Nicolas possess. With Presiding Judge Naraha, I have witnessed his performance as a judge on a number of occasions. In each instance, he has carried himself and his jurisprudence with calm patience and thoughtful discernment. He never rushes to judgment. He never jumps the gun. He takes the time to listen carefully, consider the evidence, and determine what is right. I wish I could be that patient, that discerning, and that deliberative. Quite honestly, our whole world would be a better place if we were all more like that. That is why his decisions are honored, trusted, and respected. In fact, that is why he himself is honored, trusted, and respected. And that is precisely what the CNMI Supreme Court requires as our justices grapple with the compelling legal issues of our day. As for Judge Camacho, one of the greatest privileges in my life has been to work with him in mock trial competitions. As an educator myself, I have always admired and appreciated how he understands the educational purpose of mock trials. After coaching my students for months, it was always reassuring to learn that Judge Camacho would preside over a mock trial round, because I knew that he would use it as an opportunity to educate, enlighten, and inspire my students. And it's only fitting because Judge Camacho has one of the most brilliant minds in the Marianas. I am astounded by how much he reads, how much he knows, and how much he cares. He is like that great professor from college that you could listen to all day. And with Attorney San Nicolas, I've been lucky to have been one of his clients. I've worked with many lawyers over the years, and quite a few of them are adversarial, rash, and quite greedy. That is not Attorney San Nicolas. In working with him, I was impressed by his compassion, his kindness, and his commitment to finding win-win situations. His trademark smile doesn't hurt at all in that regard. In a profession that often reveals the worst of us, he somehow finds a way to bring out the best in us. And at a time when our community is growing increasingly litigious, it is reassuring to know that an attorney like him uses the legal system not to divide us, but to bring us together. There's one more characteristic that all of these fine gentlemen possess, and something I must mention. They are all family men. No matter how busy they get, how hectic their lives become, or how stressful their work is, I've personally seen each and every one of them always make time for their families. As a father, a son, and a husband, that is something that I appreciate and something we should all celebrate. But their commitment to their families should come as no surprise, because they are simply good men of outstanding character. Whether it be the thoughtful discernment of presiding Judge Roberto Naraha, the enlightening wisdom of Judge Joe Camacho, or the kind compassion of Attorney Joey P. San Nicolas, they possess the kind of character that will only make our judiciary more just, more fair, and more trustworthy. Indeed, they are not just good men. They are great men who can make our entire Commonwealth a better place to live. That is why I respectfully urge the honorable members of this distinguished body to support their appointments during this confirmation process. Jesus Masi, again, for this opportunity to speak before you today.
Jesus Masia, Mr. De Longuero. Still open for public comment. Anyone else?
Good morning. Buenos dias, no Chairman Cruz. Senador, no, susmasin na dyan na oportunidad pa ba patatsungin ni pagod sa bigago no sa potasyon medyo para i-request Robert Sinara si Joaquin Torres na no kumumpare amin si Judge lo matatatsung gini para kumuno na o maski 20 anyos na abogado gini sa Marianas za bulan na kausa no gimana nas Judge Naraha u kadga siya muna za benatungam zo na taza si Judge ni Martinez desisyon gedi binibu pa no lalolo pa tizanya fabirodo mo na uno na abogado pa di otro todo tempo na na oportunidad para dos banda pa ma-argue dyan niya kausa essential niya matatasong kumuha West Nigita na sita gi Supreme Court. Por fatatsung za pura analisa todo siya i-line ni man mapausa gini namdu za ni gobyerno. Iman malofan siya na kausa. Todo tempo si Judge Naraha. Tawad za ni Martinez desisyon, if you know my English, hastily, no? Todo tempo pa Martinez matatsung za na natsukan intentalu trial. Zangingwa issue kahulu lang niya. Ano dyan briefest na issue. Dyan biram zumagi dyan bifang Martinez desisyon. So nigi nakasinsensya ta na si Tegi Supreme Court. Dyan gagawa so suzu zumido sa potasyon pago pata confirm si Judge Jesus Masi.
Jesus Masia, Mr. Torres. Still open for public comment. We also welcome individuals that are not in support of the appointment, if there's any out there. No one else? The reason this committee is allowing the general public to participate because we want them to be part of this Senate due process. So we want to hear how our community, especially people here in the gallery, whether you're in support or not in support of the appointment. But if no one else, once we close public comment, okay, sir. Before you proceed, please state your name for the record.
My name is Jose Crisostomo, De Longuero Crisostomo. I'm the Executive Officer for the Veterans Affairs. And Judge Naraha is my brother-in-law from my wife and his wife. double trouble. But I'm here to support my brother-in-law, and I hope that you all vote yes. So we're not going to leave that spot vacant for a long time. So it can be occupied so they can do their job in making our people obey the law. So again, I fully support, and I hope you all support my brother-in-law from my wife and his wife. Thank you.
So this is Mossy, sir. Still open for public comment. Once we close public comment, we'll not go back to public comment. So this is the opportunity if anyone else wishes to come forward. If no one else, at this time, public comment is now closed. And before I recognize the members of this standing committee, first I would like to ask Mr. Mafnas to disclose all letter submitted to this committee. Thank you.
Mr. Chairman, members of the committee, Honorable Presiding Judge Naraha, and members of the general public, in addition to the oral testimonies received today on the executive appointment of Honorable Presiding Judge Roberto C. Naraha to serve as Associate Justice of the Supreme Court of the Commonwealth of the Northern Mariana Islands, please be advised of 9 written testimonies in support of the nominee's appointment from Honorable Julie Marie A. Ogo, Representative of the House of Representatives in the 24th Northern Marianas Commonwealth Legislature, Honorable Edwin P. Odon, Mayor of the Municipality of Tinian and Aguiguan, Honorable Joseph E. Santos, Chairperson of the 20th Tinian Municipal Council, Honorable Judge David A. Wiseman, Retired Associate Judge, former Governor Ralph De Leon Guerrero Torres, Joaquin De Leon Guerrero Torres, Attorney at Law, Franny T. Damapon, Attorney at Law, Michael A. White, Attorney at Law, and a joint letter from the following attorneys: Keith Chambers II, Joaquin Torres, Robert Torres, Viola Alapuzo, Gilbert Burnbridge, Janet King, Anthony Ogun, Victorino Torres, Matthew Hawley, Michael Evangelista, Colin Thompson, David Baines, Sean Frink, and Bruce Berline. At this time, no written testimonies in opposition to the nominee's appointment has been received by the committee. Please also be advised that the committee is in official receipt of the Northern Marianas Bar Association's evaluation of all 3 judicial nominees. Thank you, Mr. Chairman.
Thank you, Mr. Mafnas. At this time, I'd like to recognize the Vice President of the Senate, Senator Corina Magofnia.
This is Masi, Chairman. Good morning, Presiding Judge Naraha,
Good morning.
and to you, to your families and friends who are here in support of your nomination. I'd like to first congratulate you on your appointment and thank you for accepting.
Thank you as well.
I really don't have any questions regarding your credentials. Obviously, you have served the judicial branch for many, many years, and so I have no questions there. The judicial plays a vital role in upholding the rule of law, ensuring fairness, and maintaining public trust. Today's hearing is an opportunity for the committee members of EAGI to evaluate your qualifications, integrity, and judicial philosophy. That said, let me start with my line of questions. Should you be confirmed as the next Associate Justice to the Supreme Court, why do you want to serve in this position at this time? What qualities make you uniquely suited for this role, and what legacy do you hope to leave the CNMI judiciary? Thank you.
I've been serving the people of the CNMI almost my entire life since coming out of law school. 25 years sitting as a judge. I am committed, and I invested a lot of time in the judiciary and learned a lot. I believe experience really counts. 25 years of experience. I remember when I first stepped in and became an associate judge. Each time I come up to the courtroom, I'm perspiring with cold sweat. Today, if someone called me to sit, I would just go out, and based on the experience, I feel comfortable. I feel that listening is probably my best qualities. I will sit and listen. And a second good quality is taking a lot of notes. In all trial, you will find that I always have a stack of notes, and I normally would do it this way, and I put all my notes in, and then I would go back to my chamber and review my notes, review the arguments, and all those. So if there's any legacy, it's basically listening. I love to listen. And that's why also I love taking, assigning myself to traffic cases, infraction, and having sit down as a traffic judge on infraction traffic cases. I get to speak with the individuals, the people out there. Very, very rare that you have that opportunity. So many often ask, why do you take traffic arraignments, the almost given to the newest judge? I like it because I get to work with the people and communicate and exchange. And with this exposure, I enjoy listening and feeling the pain or the claim that the regular people out there that comes before the court. I find that many of our community members, when they come in, they are so kind of afraid and that sort. But I think my quality is to just make them comfortable and then open up. I think that's my, if any legacy, that would be probably it. Thank you. Did I?
Yes, thank you for your answer. My next question is, in your professional or personal capacity, can you define and characterize the distinct difference between a legal opinion and a legal advice?
Advice? Family court. When I came in as associate judge, then presiding judge Manibusan assigned me to take on the family court docket. There, I with manager Pat Diaz, we created the process center, and the process center, we allowed people to come in and use the computer and file their own claims, child support, those type of cases. I enjoy doing that. It's something that I thought that the community would need access to court, and when you have access to court that opens to all the community who has claims, that is part of our strategic plan in the judiciary to make sure that any and everyone has access to court. Can I again ask you to repeat that question? I made kind
Yes.
of losing it.
In your personal or professional capacity, can you define and characterize the distinct difference between a legal advice and a legal opinion?
All right, so that is where it's so difficult when you have a pro se person coming in to family court. We have to be very careful that when we give them instruction how to file a case, that we are not giving legal advice, but basically giving them a map and navigation to go through the process of how to go about filing claims. So the advice that we give, we put in a lot of study to that, so to make sure that we don't cross the line, that the court is not being an adversary, that the court is just giving a navigational map in how a pro se would come in and navigate to the judicial process. That is the advice. That is the reason we created the process center, so that they are given the roadmap without giving them advice. Thank you.
So can you give an example of what a legal opinion can look like to the viewing public who are listening in?
Okay, legal opinion is where if a person has an issue, you look to the law, you look to case law, statutory law, the Constitution, and you take the facts that were presented to you, and then you give them a legal opinion as to how those facts, with the issue that they have through that facts, how the law would apply to that specific facts, I think.
Thank you for your answer, Judge. My next question is, as you may be aware, on October of last year, Senator Manny Castro introduced Senate Legislative Initiative 24-3, proposing to extend the private land lease from 55 years to 99 years. In your personal opinion, could you share with us your thoughts on this proposed initiative?
Normally, the simple answer would be I would not give an opinion, because that would probably come before the court. But it is a economic issue, right? Remember that when we put together our covenant, we have specific provision on land ownership. So long as we don't lose land ownership, that is something that many of our leaders, all those Senate President whose pictures are out there, these are the fundamental principle that they would like, that they would preserve, and whether it's 55 or 99, that's really something that the senator would probably do a survey and see how the people react to that. That is maybe a good way to approach it. I know we're facing economic challenges, and the senator is likely thinking about how to open up and bring more revenue into it. Maybe this is one way to incentivize all the investors to come in, knowing that they can hold on to a leasehold for 99 years. I believe this is what's happening in Palau. Leasehold are allowed up to 99 or 100 years leasehold. But it's really up to the people. Do the survey and let them speak up.
Thank you for your answer. That kind of leads me to my next question. And, you know, as you have stated earlier, we are facing a lot of economic challenges at this point in time. And, you know, I do see the incentive that legislation is providing to potential investors who are considering the CNMI a place to invest in. But we also do have existing land leases that, you know, have gone really bad to the point where a lot of the long-term leases have been almost probably abandoned. And I'm working with zoning right now to identify and determine which properties are those, especially the ones that are blighted. The issue that I see with that is that because there are many land leases that were leased for long term, we are finding out that a lot of those lessees have either left the island or have passed away, and those leases are now stuck until the end of the term, right? And recently, I introduced proposed legislation to the deduction of waste, basically, as a tool and resource for NMD landowners who lease their private lands long term and are unable to take those lands back because of the long term lease. And so I'm not sure if you've had a chance to read that proposed legislation yet, but in general, what are your thoughts about the doctrine of waste?
You are correct, Senator. There's a lot of leasehold out there that has been, I suppose, abandoned. There are buildings that are conquered by trees and vines, and they became a eyesore. But the biggest concern is many of these leasehold structures. You have squatters that are coming in, squatters that maybe have addiction, substance abuse. That would be a basis to see whether there is a mechanism where our government can come in and remove that kind of impediment that provided squatters with addiction to live in this abandoned building, and then became a sort of like a castle for them to distribute more drug substance. So having a legislation that would take care of that would be, I believe, welcomed by the community. Waste, correct, is if the building is has potential, why do we want it to just stay there and be wasteful? With the due process mechanism and having to occupy this property, perhaps there's a way that the legal process would allow for the government to come in and make sure that it's not wasted. Remember that many of these lessee, they have paid off the 55-year leasehold, so they have legal rights, but there are ways to provide notice by publication, perhaps not only one time but many times, many years, so that we continue to publicize notices that are you still coming back to effectual your legal rights on this leasehold? Perhaps they're not, and if we provided the due process and giving them proper notices, maybe there is a tool, a mechanism where the government and the landowner can reclaim the property and develop it and make use of it. But the most important is to make sure that there's no squatters and it's not eyesore, and it's another way of combating our drug problems here in the CNMI. Thank you.
Thank you for your answer, Judge. And I bring that up because the intent here is to help our people get back whatever land they may have. Land's very scarce here on our very small island, and as we know, back in the 90s, a lot of our people have leased their lands long term, and many of those investors have left the islands for whatever reason. And again, with zoning enforcing the blighted property law, we are discovering that there are many lands that that have been truly abandoned by the lessees, and zoning has done their due diligence to reach out, to communicate, to publish, in any shape or form, to try and get these lessees to communicate back whether or not they still have intention to hold on to the land. But ultimately, the idea is to revert those lands back to our people so that they may do whatever they wish they want to do with the land, and not just leave it there to go to waste. Additionally, it affects the surrounding properties nearby, so I'm sure that the neighbors would appreciate, the land going back to the true owner, so that it does not devalue their property as well. And then that leads me to the mentioning of squatters, right? Again, we don't want that happening on our islands, and the question that comes to mind with that is adverse possession. Because, as for some of us who are aware, if a squatter resides in that abandoned property for a period of time, I'm not sure if there's actually a case here in the CNMI, but I know that in other jurisdictions that has, obviously occurred. So could you share your thoughts on adverse possession and whether or not that is something that the CNMI should consider providing some sort of framework, a legal framework, to ensure that the properties are protected from squatters? Thank you.
Again, the typical answer that a judge normally gives is that this matter may come before me, and if I extensively address it, it might be a basis to recuse a sitting judge or a justice. But we do have a statute of limitation. When it comes to interest of land, it's 20 years. So law, if I would recommend to the landowner that regarding a squatter, that if that landowner observe that this property, his property, with a structure appears to be been abandoned, why not come in and just continue to clean it? Make sure that everything you do over that property, you take some kind of record, whether it's by picture or by receipt, that this is what you've done on day 1, day 2, day 3. You cleaned up. By cleaning up and making sure that the structure is standing in well situation, you're basically also preserving your right as an owner, so that if in the event the leasehold terminates, that building is still in good condition, and that would be a true benefit to the owner. But if you preserve that property by cleaning and maintaining the area, of course, not occupying it to operate, but just cleaning and operating, you can take care of a certain part of the proposed legislation that you're probably working on, and that by cleaning and preserving it, that would hopefully eliminate squatters and at the same time preserve the building. And provide some kind of a safety to the community, because anyone who pass by will see that it's clear and in good condition, and if any suspected activities ongoing, of course, we have the public safety law enforcement, DPS, that can come in also, and the zoning come in, and through their regulation, through their law, they can probably do something about it, I think.
Thank you for your answer. And that would be the ideal situation, right? Would be for the property owners to maintain and keep it clean, so that to show or demonstrate that, you know, there is a presence there, so that to avoid squatters.
And make sure it's recorded.
Yes.
Every activity is recorded.
Yes.
So if the lessee comes in, at least you can say that I spent 5 years cleaning, and these are all my expenses.
Sure.
Please compensate me for all this.
Sure. I guess the unfortunate situation, or the hypothetical situation that I am looking at, is, you know, for those of us who leave the island for whatever reason, for medical, for school, right, for a long period of time, you know, there will be an absence, right? And it's hard. A lot of people are leaving our island because they're seeking for greener pastures elsewhere, and that's understandable. So I'm trying to anticipate, you know, a lot of these situations where the property owners are not on island and are unable, for whatever reason, to ensure that their properties are being maintained. And so a squatter comes along and establishes some kind of residency there for a period of time, and none of the property owners or family members have, you know, raised the issue or concern. I'm trying to see how can we protect those people who have left the island for, could be medical reason, could be whatever reason there is, right? And they just didn't have the means to maintain the property. How can we protect those from squatters taking over their property?
Perhaps the tool that we can look into is the zoning. The zoning office may have the legal tool to come in and look into this property that seems to be abandoned. I have not read thoroughly the zoning law or the regulation, but I'm sure that there could be a tool there to find ways to take care of that abandoned property.
Okay.
Maybe another agency can do that, but I think the zoning is the right office.
Yes. Thank you for your answer. And I am working with zoning to kind of address a lot of those potential issues that may arise in the future, so that they have some type of framework to use as guidelines to carry out their mandate. So thank you for your answer. And one last question, Chair. I know constitutionally, CUC is the only authorized agency to provide utility service. And just this morning, I received information that the FAC rate will be increasing from 22 cents to 24 cents. Additionally, I just ran into one of the commissioners, the PUC commissioners, this morning as I'm making my way here, and it was shared with me that CUC is petitioning to increase the rate from 22 cents per kilowatt to 44 cents. The first thing that comes to mind is, what is CUC thinking? We are already in a state of emergency and devastation, to our economy. A lot of our businesses are closing down and are unable to continue their operations with these high utility costs, and to increase the rate from 22 cents per kilowatt to 44 cents. That's double the price of what we're paying right now. What message are we sending to our business community? Are we just trying to kill them before? Right now they're just trying to stay afloat, right? And to do that, in my opinion, is very irresponsible. But I guess my question is, with the way the Constitution is written right now, authorizing CUC as the only entity to provide utility service, I've also introduced legislation to deregulate that and open up the market for other participants and operators to come into the CNMI to also provide utility services. In that way, there is a fair competition. In most cases, right, when there's competition amongst businesses in the same industry, it usually provides better services, customer service, and the cost of service is a lot affordable. Take a look at the telecommunication and similarly to like cell phones. Back then, it was probably just one service provider on the island, and it was very expensive to own a cell phone. Now, with two companies on the island, you know, it's a little bit more affordable, but still very expensive compared to other jurisdictions. So, if you haven't had a chance to read or review the legislation that I propose, just on the surface, based on what I have shared with you, what are your thoughts about deregulating the only entity that provides utility service and opening it up to other market participants?
Thank you, Senator. Definitely that will go up to the Supreme Court. But the covenant, the Commonwealth of the Northern Marianas Islands, we're little islands, small islands. You look around, I think the Commonwealth is super rich with natural resources. We have rights to 3 nautical miles as provided to us by the Department of Interior, by I believe that was the Territorial Submerged Land Act. What do we have out there? Also, the federal law has the 12 nautical miles authority. But remember that the Commonwealth, when we were under the United Nations, these are our resources: the seabeds, the ocean, the waters, the air, the sun. These are all potential energy. But we, by the covenant, we, as a part of the United States, we should not let the door close on these potential resources. If anything, we should ask our 902 and our leaders go out and continue to knock on the Department of Interior, the President, Congress. Give us some kind of a payback for all these resources that you have taken by being a part, by the CNMI becoming a part of the United States. There's just so many rich minerals out there. I remember there was this several months ago where there was this seabed mineral proposal, and it seems like it's really beyond the 12 nautical miles, close to the 200 nautical miles that the Department of Interior has authority over. If anything, let's see whether we can ask for a royalty if they have gone and mined those those minerals. Let's ask them for royalty. Who knows, those rich resources that we have, it could be in the trillions. Royalty 10%, 5%, I don't know, but that could be billions if we get it. President Trump is so much into oil, gas. Our Pacific Ocean seabed is rich of that. We have to go out and ask for them. Give us some part of that. AI, it's this technology now, the rare earth that are being sought by the president. Greenland, Iceland, they want that rare earth because of the technology that is now overwhelming the nation. These are our resources. Give us some kind of a portion, even if you have the authority. But look at us. We're the CNMI self-government. Our revenue is really hurting. But we have the gold out there, the mining, seabeds. If we could just get some kind of royalty for the federal government mining those, even beyond even if we say no, it's really their authority. So at the very least, give us some kind of payment, royalty maybe. Imagine trillion, 10% of that. Maybe we can get like 100 million every year, and that would take care of our budget. I don't know, but the resources is here. We have the sun. We can generate power. We have water, the sea, the ocean wave. We have the wind. Our wind here is really our at the island of Saipan, Tinian, and Rhoda. It's so small, but it's so beautiful with the wind crossing our islands and the resources there. I know that if some company comes in and wants to develop that, we always think about, oh, Mr. is going to get rich. Why don't we think in terms of the people of the CNMI becoming rich? Instead of getting this 44 cents per kilowatts, it's there. Our resources is there. Let's help each other. Let's be one community and get some company to develop all these resources. Who knows? If we do that, maybe our power will be free, right? It's there. Our islands is super rich. Why is it that we're not taking opportunity in benefiting our people? So if we just become one instead of fighting, let's get these resources. It's there. The sun, the water, the minerals, it's there. I think so. Would that take care of the 44 cents kilowatts?
I believe so. Yes. To do small sini zomo answer, Judge. I really do appreciate your input, and as you stated earlier, we are rich in resources. There's so many resources that we haven't. I don't want to say haven't tapped into, because I'm pretty sure there's been a lot of discussions that have been taking place, for many, many years. It's just we've never really taken real action to realize a lot of those resources, to include geothermal and everything else that you have mentioned, right? And we really shouldn't be in this predicament, if we can come together and focus on the betterment and well-being of our Commonwealth. So I appreciate your answers, and that's all I have for now. Thank you, Chair.
Thank you, Vice President. Now I would like to recognize Senator Kavu.
Thank you, Chairman. And good morning, Mr. Naraha.
Good morning, Senator
I'm
Kavu.
happy to be coming back on the roundabout from the municipality, beautiful island of Rhoda, and Tinian Online. I really don't have much questions. I just want to, first and foremost, for the record, if it weren't for, the former CNMI Supreme Court, Mr. Perry Enos, Associate Judge, we'd like to come in and thank him for leading the way and giving the opportunity for, the next person in line. On top of that, the Governor David Apateng and Lieutenant Governor Dennis Mendiola for confiding and fighting the right 20 plus years, of service. It was without a doubt, looking at the extensive resume and the team you have at the judiciary system. I know this is serious business when it comes time for the process and to ensure that, the nominee has what it takes to lead from, backyard. The Superior Court, the Supreme Court, from Superior to Supreme Court advancement. As we go along, and all the 9 testimonies plus the initial family testimonies, a lot of professional members in society here in the Commonwealth and those abroad that are looking forward to get you in place so we can move the Commonwealth forward as far as judgments are concerned. Looking at the pros on your extensive judicial experience, Mr. Naraha, you have handled complex cases, civil cases, criminal cases, and constitutional matters. I like where you have that educational aspect, engaging with the people and over time, and experience, and then looking at the Constitution, at law, what are the patterns of decisions you have to make over time, and you'll see the certain patterns and what are the outcomes and how we can better our decisions and the looking at the system itself, how to improve everything. So your experience speaks for itself. Institutional knowledge from, when you shared Q&As in the island of Rhoda and Tinian, I kind of jumped. When I was talking about the relationship that, Chairman Senator Jude mentioned, is how is our relationship with the federal system versus the judicial system and the court? How does that, me not knowing the background, but ensuring that we have that relationship to ensure that I was trying to bounce because I know a lot of people back in our municipality, when it comes to employment, they come to me as a senator saying, how is our, labor and immigration, federal versus local CNMI, and where are we at currently? And, we're in this bill-making process. But that's the judiciary part of it. How do we address it for our public, especially those that we depend on for labor force and so forth. So your institutional knowledge is very commendable, that framework. Administrative leadership, I know you shared, the different, and I'm looking at your resumes, the different family court, criminal cases and all that, and the educational aspect. So I'm just maintaining the efficiency and the case management standards. The other one is your commitment to public service. That was one at hand. And taking a look at the, plus you have your judiciary system doing an assessment on this initial process, So when I look at the pillars of the provisions that we need to have you in place, your legal ability, we shared that in the 3-location process, your integrity and impartiality. I like the way you shared, let's get the people involved. Let's do a survey or a poll. It's not just one, it's, all members, all stakeholders. So that's being very impartial, your communication skills, without a doubt. very well. Professionalism, and I know they did mention how do you handle cases in your temperament. You know, I didn't realize that that's part of one of the pillars in, you know, you don't get up and, you know, you're in control, and how the other lawyers and judicial systems say, you look, you analyze. I'm a note taker too as well, so you really take your time to digest it and using the rule of law and all that stuff. So, you know, these are just some of the things that I wanted to share with our chairman and community, and we look forward to the due process and everything, but I'm just looking at all the elements it takes for you to handle the position at hand. So thank you for accepting, your family for their sacrifice on saying, okay, this is the next level we need to be at, and we go over the due process. So appreciate that. Our current testimonies for the island of Saipan, our beautiful island, and our committee members and our chairman. So I yield, and, you know, we look forward to continuing the process.
Thank you, Senator Cabo.
Thank you.
Thank you, Senator Cabo. Now I would like to recognize Senator Castro.
Thank you, Chairman, and thank you, Judge. You know, the past two hearings on Tinian and Rhoda, I believe, were enough to enough information was gathered in terms of your judicial philosophy, your experience, as well as all the documents that we're receiving from the public, as well as to get a better understanding of your approach to the rule of law, really in depth. So I really don't have any more questions for you. I just wanted to make a statement, and thank you for you know, stating that you cannot give more comments on a lot of these controversial initiatives that especially introduced by myself and Senator Karina. But just to help you out and help all the other judges out, when introducing an initiative, especially something that's going to involve the Constitution, amending it if need be, it's always important to look back and understand what our founding fathers and our people were thinking of back then. Any legislation. In regards to Article 12, it's a very sensitive subject, and even before I decided to introduce that initiative, it's not the first time. There are other senators before me that tried to do it. And you know, I had a heart-to-heart with my grandpa's brother, Pete A. Tenorio, and I asked him, what were they thinking back then? Also, why did two of our Carolinian representatives walk out and not sign the covenant? It's a really good process to understand the logic and the thinking of those concepts. Everybody had a good reason. In fact, some of those very concerns that some of the members of you know, some of our founding fathers had, we're facing today. A lot of those challenges are not really what was envisioned. There's a lot of overreach. But you know, in terms of legislation, it's very important, just like in law, to look at the facts, look at the evidence. So in the legislative side, it's important to really look deep into the data and research, and look at the system. To be honest, I feel like our challenge in our system is education. Not just education in terms of you know, getting your degree or anything, but it's education about knowing our history. You know, even the war that's happening or the conflict in Iran, knowing what's the cause of that. Even though it's so far away, we're being affected. And like you said, we do have a lot of natural resources. There's education in terms of the Inflation Reduction Act, which we missed the boat. In your example, you talked about investing in ourselves. If we didn't miss the boat and we tapped into the rooftop solar, right? And we studied and we understand like places like in Hawaii, in the island of Kauai, which their utility is owned by the constituents of Kauai. It's a co-op. At this point, I think we need to focus on what we can control, and there's a lot of things we can control that can really help. Part of it is appointing great people like the 3 people we have up today, and getting more of the right people into the right places in our government. A biggest challenge is that. But at the end of the day, whether it's an investor that wants to come in and build a semiconductor or anything, we need an educated workforce. Education. And we need to learn history. We need to learn all those mistakes that we made to prevent it in the future. I just really want to thank you for all your service to the community. We did get a lot of letters of support, but also I've been into one of your cases, and I just appreciate your proactiveness, some of the guidance, and especially the listening part. So again, Judge, thank you for your service, and Chair, I have no further questions.
Thank you, Senator Castro.
Thank you, Senator Castro. Now, I would like to recognize Vice Chairman of Senator.
Susmosi, Mr. Chairman. Buenos dias para Honorable Presiding Judge Roberto Noraha dan familia mo todo ni mangai gini. Siguiente siya naman distingizon na publiko, and specialmente maniega gi zotan no social media. First, I wish to thank you for your patience, really, because it was the intent, and I want to echo what the good chairman is saying, to allow our community opportunity, to sound off or share their thoughts about the Senate process of judiciary. And for those that probably are aware but not really looking at it in this perspective, this is the first time in history that we have 3 judiciary nominee that's ever taken place. So in that regards, congratulations for being part of that history.
Thank you, Senator.
So, during my some of my comments, because I really appreciate your insights, and I really like your answer to Vice President Magofnia about your legacy, about just listening, and and I think that's an attribution that many of us we tend to forget. Politicians. Nevertheless, I appreciate that, and I want to try and emulate some of that moving forward, and I encourage the younger generation to take heed in what your comments are with regards to that. Presiding Judge, one of the things that I mention of you is because of your in-depth knowledge of the Constitution and the Covenant and all that over the years of service, from being a practicing attorney to an AG and all that. And it seems to me that although the CNMI is fairly young in terms of being part of the political union of the United States, we've been through a lot. And our forefathers, that when they negotiated, I think there was a sense of comfort. There's no such thing as a perfect document, correct? We need to compromise, in order for us to get to the next step. So, was, in your opinion or in your view,
and if you don't have it, that's okay. Was a non-voting delegate ever contemplated to be a part of our relationship to the United States, other than the 902 sections or any of the covenant sections? Was it ever contemplated in any excerpts? Because this 110.229 is a significant U.S. law, because that actually took away our immigration. That's clear in the covenant, but there wasn't any. I don't know. I mean, I haven't gone that far back to negotiate to see if a non-voting delegate was ever contemplated to be part of the negotiation. I ask this because I'm just doing a quick cursory review on the GDP of the CNMI post federalization of immigration, and I recalled in one of the conversations, not just to you but to many of our constituencies, they're asking us, is there a way that we can revisit the immigration policy so we can see how we can continue further negotiating how best to allow our region here to really survive as far as the workforce that's needed to sustain a fledgling, a suffering tourism economy, a hospitality. And there's so many hotels that are closing. There's so many businesses that are following suits. And there's a lot of federal oversight, perhaps, policies that may or may not, or more so may, are affecting our way to do business here as a government. So in your opinion, do you think, was there ever a contemplation of such? That's you do, but if you don't, then that's okay. I understand. And I think I ask these questions for the benefit of our community, of our young leaders, and of our students to really delve into this, because CNMI is really in a difficult situation today.
I'm looking at my covenant. I believe there's a provision in the covenant that allowed us to have a resident representative.
Correct. Nga gaya na lo prego respectfully again, because we do endorse, because I remember by the time in my younger days in the legislature and public service, the selling pitch was that we're being disenfranchised and inundated. There's some concerns with the way we do business here, and yada yada yada. We need to take over immigration. But also along come with that is we also need economic survivability. We need the constant guidance, because that's part of the covenant.
So Vice Chair, have you heard about the insular cases?
I didn't want to ask that because of where you're situated right now, but out of respect for you, sir.
So basically, remember the insular cases is the reason why we have the covenant, the incorporated territory. That basically the insular cases that describe the covenant. It's two entities meeting to form a relationship. That's our covenant. The Commonwealth, the CNMI, is seen as a party, and the U.S. is another party that got together and create a relationship. So these are the insular cases where, if you go back, we have Puerto Rico, we have Alaska. I think the closest would be Alaska. By the Russian treaty, Alaska had created a incorporated territory that eventually became a statehood. And I think the insular cases were not a state, but the way it should be would be to look at Alaska. It started as an incorporated territory, and then it became a statehood. And becoming statehood, that's where true representation is given. Even if we have citizenship by our covenant, those are the fundamental provision that our forefathers negotiated in creating the covenant. So the covenant, like Alaska, provided many rights to our people, but it's short of becoming a statehood, right? A statehood, they have a House representative, they have senators, and they vote for the president, and they have true representation in the U.S. Congress. We don't, right? We don't have that. And if we look at Alaska, Alaska was incorporated and it became a statehood. Why is it that we're not like that? So that is where we should have got to know our rights, so that we have true representation. But perhaps because of the population. Look at Puerto Rico; it's still a Commonwealth. Look at Guam is unincorporated territory, meaning it's up to Congress. When we negotiated our covenant, we only have so many fundamental provision that applies to us. If you look at Covenant Section 105, the fundamental provisions are: 1, the political relationship with the U.S. Article 2 is the NMI Constitution. Article 3 is the citizenships. And 501 is the application of constitutional provision. Not all, but it's all enumerated in there. And then 805 is the ownership. This two provision, especially land ownership, that really is in conflict with the U.S. Constitution, where you cannot limit the rights of that. So we negotiated that, and that's the whole thing about our covenant. It's just the document that created our relationship. But the insular cases, there was a conference one time here in the CNMI, put together by Chief Judge Mona Magnolia on the covenant. And one of the concerns that were raised was that what happened if these insular cases are overturned by the U.S. Supreme Court? Remember that through the insular cases, we have this land ownership.
Sure.
We have the rights to Republican form of government. Are we going to lose those if we became if the insular cases are overturned? I don't know. That is a concern. There are many scholars out there that says the relationship, the interior and incorporated concept is really against U.S. Constitution, and that's why the concern was raised whether eventually the insular cases, if overturned, we will lose those rights. We are in a crossroad. I don't know what's going to happen, but since we have a covenant, I think we should continue to work with the Department of Interior and see whether we can, and through them, we can knock on the doors of the U.S. Congress and the President and give us more benefits from the covenant. We lost immigration, we lost the wages and the wages that were provided to us. Can we get it back? I think the government cannot really hurt us, right? Because of our garment, of the the way we handle the garment industry, we lost our immigration and wages. So if we lose it, I think we can get it back. We just have to find ways to do that, right?
Yeah. I have my own sentiment about that, Justice. I mean, presiding judge, but I appreciate the insight. I think I just feel like there has to be more discussion as far as contemplating of non-voting delegate, you know, as a companion provision. Now, I'm not saying it's a bad thing, but there are some issues that we need to kind of flush it. But I appreciate that you keep flushing it down to say that
To have representative of Congress would be a statehood.
correct. Yeah, but
So-
something short of saying that.
Right.
But my only concern, Judge, is I feel that we are being cornered as a region here, and stopping short of what I'm thinking about to say, stopping short of that, because out of respect for the system, you said it yourself. We have abundance of resources, you know, with the water, land, and all, and air. But before I lose my train of thought, I want to just read this out because this is really good information. The GDP was stagnant in the CNMI pre-federal control from 2008. We are hovering about 94, it's 1 billion, 94 billion, or 0.94 billion. It's almost $1 billion. 80, 2009, 2010, 80, 2011, 73, 2012, 75, 2013, 77. And then in 2016, it went up to 1.23. And then 2018, of course, everybody knows the infusion of the gaming. It really, and then of course, pre-COVID, 1.18 billion. And then the recovery phase went back down to 90.94 billion. So we're showing strong rebound post-COVID, obviously, because there's some infusion of some federal funds. But it's the now that we're concerned with, because everything is being, there's more scrutiny, perhaps. And I'm going to keep saying this because I believe that the one-size-fits-all policy that is rendered in the U.S. Congress, it doesn't necessarily it shouldn't apply to the same manner of that of the lower 48 to that of the CNMI, because it's really hurting us a lot. And let me just say this, in a pre-COVID GDP decline from peak, let me see this. There was a there was an immediate post-federalization decline from 2009 to 2012. Structural adjustment, perhaps, maybe from us taking over our immigration to divesting it to the federal. As far as the immigration, there's like strategic interpretation as immigration policy. The policy changes, it kind of stagnates the growth. We lost of flexible labor supply, and of course the garment industry collapsed, and it kind of like it forced a contraction of our region here. The key drivers the last 5 years is the federal stimulus, the gradual tourism return, infrastructure plus defense spending. That's obvious with the island of Tinian right now. They even went on to compare us as that of Guam. So I guess, Judge, sticking to more on the policy side, based on the information is like we have the CNMI still lacks labor pool, self-sufficiency, sector diversification to that of Guam, same as Guam. There's a lot more people down there, and then there's a lot more associated business, and the domestic demand is still very suspect. So again, not that I'm harping at any federal policy because obviously there's a lot that's advantage for us, but what I'm pointing out is the now. It did not uniformly suppress growth, but it introduced structural constraints for us here, of which many of us here, especially in the legislature and whoever is going to be the next administration, we need to really sit down and navigate forward. Because in as much as my good colleague here, Senator Manny, is introducing some constitutional amendments, it's the now that we need to worry about. And I flag and I agree with you of revisiting the former 110-229, the federal immigration, and see how we can better tailor that so that it's advantageous for us, so that we can almost like self-reliant gini mga patafan manangokumas from somebody, because although we are part of the U.S. political family, we also have an identity here that you mentioned it yourself with your comments, that you want to make sure that our traditions, our values are preserved. And I have to say, one of those tradition and values that we hold so dearly over the last maybe almost 1,000 years it's a federal policy that actually says no more. So Vice Chair, if you look at the applicability of laws in the Covenant, Article 5, Section 501, A and B, these are all the constitutional provisions that are made applicable to the CNMI. But Section 502, these are laws. These are everyday laws that are coming out of the U.S. Congress. 502, 503. But you know what? When I was reading the Covenant, what really amazed me was right after we enacted the Covenant, there's Section 504. And that section basically, it's already passed, but the President appointed a commission on federal laws. And when he did that, it has this formula that says Federal Commission look at all the U.S. laws and determine which are not applicable to U.S. laws should be made applicable, which applicable U.S. laws should not be made inapplicable, and to what extent and what manner. Did we ever come up right when the covenant was enacted back in 1975? Did we have this Commission of Federal Laws that study all the federal laws that are made applicable? And was there a study that says this existing federal laws that are applicable should not be made applicable? I don't know. We should go back and visit Uncle Pete Tenorio, and find out where are these documents. I remember when 902 was created, there were several lawyers who were hired by the 902. I think Macmillan and Woodworth, I think. There were two lawyers that served the 902, and they had all these books and study when they were negotiating with the Washington Department, the U.S. representative. What are these? When we look at the, this formula about what applicable U.S. laws should be made inapplicable, and then we look at 506, which says, look at the existing our tradition, customs that should be applied. When looking at this, it'd be nice to see those. It'd be nice to have this federal Commission of Federal Laws again, because guess what? It's if the president appointed that commission, he's the one who's paying it. So where are all the studies? It didn't stop short of saying there's a sunset provision of that?
Yes, it says that
506.
this
Sorry, I don't
report
have it. I can.
it has to be submitted 1 year after the termination of the trusteeship agreement.
ILO provision in the covenant still intact, correct?
Yes,
So that means we can always
I'm not sure, but
we can always go back. Let's say, for example, the panel right now, Governor Apatang is
we have the
the
902. Yes,
So can they
but
talk about that? Because
yes,
it's part of
let's.
the covenant.
How about the Commission of Federal Laws? Because the U.S. President pays for this
Yes.
group.
Yeah, because and I'm glad that you're the one that pointed that out, Judge, because it's really, I don't know. I mean, if I'm the only one, like probably a lot of that shared that there are some challenges, a lot of challenges right now in terms of the application of such
When I
policies
was
coming
the
down.
when I was the Attorney General and I had my Deputy Attorney General, Mr. Eric Smith, I assigned him to do federal laws. He was supposed to collect all these documents when 902 was negotiating in the early years. Even the report on the Federal Commission of Federal Laws, I would think that those are still in existence. But where are they? It'd be nice to have access and see what it is, right?
So, yeah, thank you, Judge. I'm not going to delve on it anymore, but I always like to get your views. Again, thank you for being here and for being patient. And my wadesisty na exchange and conversation, and thank you for your services over the last several years. In all capacity, and I think you're going to be seeing some of these, hopefully, in the media, not necessarily in your docket, but when you.
So last year, I remember when I was working for the Public Defender's Office. I think it was Governor Pedro Tenorio who asked me to go with Pete A. Tenorio and just observe how the 902 work. So that was Pete A. who was chairing the 902 then. And so I was asked to kind of just observe. And I went with them and we went to watch San Francisco first with the whole group. Senators and some of there were appointed members from the Senate. We went to Mr. Homeland's office in San Francisco, and this is where the 902 were working together to go to D.C. and negotiate with the Washington representative. And when I returned back, the governor asked me, "Do you want to work for the 902?" And I said no, because there were like 9 members, and one lawyer should. Every member has his own position, and it's so difficult to work on each of the member with one lawyer. But when we went to Washington D.C., that's where I met McMicken, I believe, and Woodworth, and those are the 2 that we should look. I don't know whether they're still alive. But they were really the legal counsel for 902, and they have a lot of documents coming out of these negotiations. So where are they? I would like to see whether we can get back, because this is what Senator Castro said. We have to look at the past to see what is it that we're facing now. And these are documents that we need to look into. Thank you.
Jesus Masi, Presiding Judge, Jesus Masi talo sa. Saludo para ako sa ni familia mo ni mga igam gini. I'll yield back, Mr. Chairman. Jesus Mosi.
Thank you, Vice Chairman. And I know it's a very lengthy. I apologize for the family and members of the general public in the gallery because for the lengthy public hearing. But this is very critical and very important that we have to go through this process to be able for the public to see that the body of the Senate are transparent on everything that is raised by and raised by concerned citizen. And since I mentioned in all my statement opening remarks that we value all public input, so any input that is brought before this committee, we have to be transparent and raise that raise to the appointee that relates to such an appointment position. So, Presiding Judge Naraha, since you are designated judge in charge of the Superior Court and responsible for managing and the judicial process, overseeing court administration to ensure that trials are fair, assign cases to manage calendar, supervise staff, and manage court budget. So I think it is important that for the benefit of the general public that don't have the access to understand the complete process of the judicial system. I know there's a letter submitted to this body by the AG's office, so I have to make sure that since you are in charge, to be able to make everyone that are listening, either today in this gallery or in social media, so that they can be completely acknowledge the process of the judicial system. So, in regards to disciplinary procedure against a judge for making multiple erroneous decisions, to tell me the difference between the legal errors and how it was corrected, between the legal errors and the judicial misconduct, and how both is corrected, so that general public can completely understand the process and not seeing us as members of the Senate that did not raise this issue and be corrected, so people can completely, like I said, completely understand that there's a due process. So can you tell enlighten this body the difference between the legal errors and the misconduct?
So if there is legal challenges in the way a sitting judge decides on cases, the way to correct that would be to appeal to the Supreme Court. So you file a notice of appeal, and that's how it goes up to the Supreme Court and address the matter there. Misconduct is different. When we talk about the judge's conduct, even lawyers' conduct, there is a committee within the judiciary. The Chief Justice is responsible in hearing complaints about the conduct of a judge. If there is a complaint regarding the conduct of a judge, it goes to the Chief Justice. The Chief Justice assign a person, more likely a lawyer, who would go and investigate the recommendation, whether to go before the Supreme Court to put forth the charges, and then there will be a hearing. I believe that happened in one of our judges. There was a hearing, and then the Supreme Court will make a decision regarding the charges of misconduct.
Okay. So is there any specific number of erroneous decision that probably might trigger a mandatory disciplinary action on legal errors?
On cases regarding a judge sitting and deciding cases, it's the answer is no.
So actually, for the benefit of the public, actually is corrected through to appellate process, right?
Correct.
So not necessarily a disciplinary action, but corrected through appellate process.
Correct.
And only misconduct, which is like misconduct in public office, bias, and political influence. Those are right.
Those are different
Those are
processes
taken
again.
by disciplinary action.
Correct.
I appreciate that, Presiding Judge, so that the public will understand
But
the
this
process.
This is also a third process.
Yes, sir.
The
So
third-
there's no numbers of errors that will trigger a mandatory disciplinary action on legal errors.
I'm not sure, but there is the Senate power to impeach a judge, right? So that would be a third process.
On legal errors. So just to completely understand what I mentioned earlier, that it has that the corrected
yes,
to correct a legal errors is through appellate process.
correct.
Okay, thank you. So I appreciate your time. And like I said, I have to address this for the benefit of the public so that can completely understand that this body is not hiding anything, but rather to address how the process should go in a judicial system.
Yes, Mr. Chair.
I'm correct, right? No,
Yes.
Presiding Judge? So, any other members that wishes to raise questions before I continue with the agenda? No. Okay. And Presiding Judge, I know that you have all the credential and everything that we have in our, but since we're given by the Constitution the advice and consent, so as a chairman for this body, my advice is you must always be independent of external pressure, including political or media influence, and make decision based solely on the law and relevant facts, because this is very essential for protecting people's rights and making sure that equal treatments are given to everyone.
We do our best to
Sisus
stand on that position.
Masi.
Thank you.
At this time, no public comments are taken. Let the record reflect that all written testimonies will be included in the Senate Standing Committee recommendation report, along with oral testimonies taken this morning, and the two other public hearing in Tinian and Rhoda and Tinian, and will be forwarded before the full Senate members in consideration for confirmation or rejection. At this time, before we adjourn, I would like to extend on behalf of the members of this standing committee our sincere appreciation and gratitude to Governor David M. Ampatang and Lieutenant Governor Dennis James Mendiola, the Governor's representative, Mr. John Paul Regis, the appointee, the presiding judge, Roberto Sinoroa, and most especially the members of the general public for your participation and involvement during this important public hearing process. And we certainly hope that we continue this dialogue of communication between us, the elected officials, and the public to keep you abreast and informed of our current and future Senate hearings ahead that relates to public best interest. This concludes this public hearing for this morning. Do I hear a motion for adjournment?
So move.
There's a motion and was seconded for adjournment. All in favor of that motion, say aye. Opposed, say nay. Motion carries. This public hearing this morning is officially adjourned. Thank you.